Thanks for joining us for the Member xCite presentation. The Member xCite presentation is informative, interesting to the audience, and showcases the strengths of the presenter as an entrepreneur and their area of expertise. It's not a sales pitch, it's a 10-minute educational and insightful exploration into what they do. And of course, it's exciting.
Ladies and gentlemen, please welcome our xCite presenter today, Anika from W&D Law, to present to us on legal tips for businesses. Having clear written agreements with employees, contractors, suppliers, and clients is so important in business and has been emphasized by the High Court in recent decisions. Anika will provide legal tips about written agreements and how having well-drafted agreements can reduce the risk of dispute. Anika is a lawyer and director of W&D Law. Her areas of expertise are in commercial law, general civil litigation, and estate disputes. Anika drafts and provides advice on all types of commercial agreements such as shareholder agreements, terms and conditions, services agreements, and employment agreements, to name a few. Anika represents clients in general civil disputes such as claims about debts, shareholder disputes, property disputes, and employment disputes. Anika advises and represents executors, beneficiaries and claimants in family provision claims and probate disputes. Ladies and gentlemen, please put your hands together for it. Anika Fleet.
It's generally about agreements. In business, we enter into agreements with our clients or customers, our employees or contractors, our business partners and our suppliers. As individuals, we enter into agreements sometimes with our family members, our friends and acquaintances. Agreements can be wholly in writing, partially in writing, verbal, or they could be implied by conduct. What I want everyone to take away today is no matter the circumstances, your agreements should always be in writing. This seems simple enough. You already know you should do it. Yet time and time again, I come across very intelligent people who still don't put their terms of the agreement in writing, and they enter into verbal or vague agreements. So I wanted to speak about this topic today, just to remind everyone. All agreements you enter into should be in writing that clearly specify the terms of that agreement. One part of my legal practice is acting for clients in civil disputes. And what I've found is that a large number of those disputes have resulted from verbal or vague agreements. One party believes one version of events and the other party believes another version of events. Who's right? It's often hard to say. Too many times I've worked with clients to piece together the events that have occurred. Sometimes people don't realise the terms of their own agreement. Sometimes the terms of the agreement have been varied verbally so many times over the course of the event that they lose track of what's actually been agreed in the first place. To name a few, I've seen disputes over contributions made to property where the contributions haven't been properly documented, disputes about the amount that business partners should receive as remuneration from their business, disputes about how much someone should charge for their services, and disputes about whether services have been adequately provided to then enable the service provider to charge their fee. I've also seen disputes about whether a person should be classified as an employee or a contractor, and disputes about whether there's been a gift or a loan of money. Many of these disputes could have been avoided if there was a clear and well-drafted agreement at the outset when everyone was getting along and was excited about the venture that was about to take place. Representing clients in these types of disputes and seeing stress, anxiety, and the cost that they go through in trying to reach a resolution or a court determination has made me more passionate about this topic in reminding everyone to ensure that they get, whenever they enter into an agreement, to make sure that they document that agreement and that the terms are clearly expressed in writing. If someone does wrong by you, which may still happen even if there is a written agreement, it is easier to make a claim or defend a claim if the terms of the agreement are in writing. If it's not possible to get your agreement in writing, then make sure that you have some written documentation that will assist in identifying the terms. This could be emails, it could be quotes, it could be purchase orders, it could even be handwritten notes of discussions. In February this year, the High Court handed down two very important decisions in the context of a dispute about whether the claimants in those cases were employees or contractors. The first case is Construction, Forestry, Maritime, Mining and Energy Union, first personal contracting. And the second case was ZG Operations and Jonesworth. In both cases, the parties had entered into independent contractor agreements, but the claimants claimed that the substance of the relationship was really that of an employment relationship. They were claiming superannuation and employee entitlements that they did not receive as contractors. Historically, the courts have taken this multifactorial approach to determining whether a person is a contractor or an employee. There would be an examination of the written terms of the contract as well as the conduct of the parties. However, in these two cases, the High Court determined that where the parties have comprehensively committed the terms of their relationship to a written contract, the characterisation of that relationship as either an employee or a contractor must proceed by reference to the terms of the written agreement. So both claimants in these cases had agreements that described them as contractors. So no matter what actually happened in conduct, in the conduct of their arrangement, they were unsuccessful in their claims because they had that written agreement. The cases were a huge win for businesses to be able to confidently rely on their written agreements, and it also serves as a reminder to make sure that there's written agreements that clearly describe a person as either an employee or a contractor. For employees, agreements should also classify them as either a casual employee or a permanent employee, because the same mistake could still be made. If there's no written agreement in place, the court will look at the conduct of the parties and could find that a person is an employee even if the business thought that they were contracting with that individual under a contracting arrangement. If there is a written agreement, there's more certainty for the parties and less ability for a person to make a claim. So moving on now to agreements with clients or customers, what terms should be considered in that agreement? So my tips are: clearly identify the goods or scope of the services so there can be no confusion with what's being supplied. Specify the price and time frame for payment. If goods and services are provided before payments received, there needs to be terms for interest for late payment and the ability for the business to claim any enforcement expenses if the client doesn't pay. In the case of goods, it can be useful to have terms enabling the seller to take back the goods or retain an interest in them until payment's received. When does the agreement begin, and under what circumstances can the agreement be terminated? Is the term for a fixed period, or can either party terminate it by providing notice to the other? Terms about cancellation of orders or appointments or rescheduling have become more important as a result of the stop-start of the pandemic. How much notice for a cancellation or rescheduling of an appointment should be provided? If the business will be out of pocket as a result of the cancellation, should a fee be charged? We've seen this more recently come about with restaurants and cafes now charging a cancellation fee. The final thing to remember in your written agreements with the clients is to limit liability as much as possible. It's obvious. So another area of business where written agreements are necessary, and I wanted to touch upon, is between business partners. So again, my tips for business partners are: have a well-drafted shareholders or partnership agreement which sets out how the company will be governed, the types of decisions that require unanimous or majority votes, the process to be applied for exiting the business. It won't necessarily stop issues arising in the business, but it will create legal rights that the parties need to adhere to in the event of a dispute. Also, have employment agreements for all people who are working in the business, including the owners and the directors. When board meetings occur and resolutions are made by directors or shareholders, always minute the decisions made at those meetings. Have a loan agreement if money is to be advanced as a loan. The shareholders or partnership agreement can be put in place at the time the business is established, or it can be drafted or updated later, especially as the business goes through different phases of the business life cycle. So what I've provided today to everyone is what we call a business e-guide, which is a document that can be found on our WMD Law website. It contains all the essential information that we think businesses should know about. So there's a lot in there. Take a flick through, take it away, and just remember for today, the takeaway is: if you're entering into an agreement, or you know someone entering into an agreement, make sure that they put the terms of that agreement in writing. Thank you.
question?
I just wanted to ask you, so with that, the High Court ruling on both, they were both earlier this year?
Yeah, in February.
Yeah. So before they were relying on conduct, and now they're not if it's tight in the agreement. Is that what the ruling was?
It's saying if you've got a written agreement that describes someone as an employee or a contractor, then the parties should be able to rely on that agreement. You've both signed a document that describes the person as what it is. So what then actually happens throughout the relationship isn't now, it's unnecessary to look at that.
So do they in those cases, did they look at if the conduct had changed away from the agreement?
Yeah, so that's what these people were claiming. Like the claimants were claiming that what was happening in their relationship
Was different.
Was an employment relationship because of the features of that relationship and how they operated in practice.
Yes, that's pretty massive.
Huge.
That's a very big.
Yeah. And it follows from, like last year as well, there was also court decisions in the employment sphere about permanent and casual employees.
Yeah.
And I actually acted for a group a couple of years ago who were effectively casual employees, but with a large company. But the way they worked for this company for like over 20 years, and it was really clear that their employment was permanent, not casual. And I was very lucky because we got a settlement for those employees before the courts handed down these the most recent High Court decision in that aspect. But it also says now...
Because that's just flipped the whole point of view on that part of the law, though.
Yeah.
So the unions would love that.
No, they hate it.
No. Joking.
Sarcasm,
right.
yeah.
So,
Well, yeah. So, it's an interesting area. It's been developing for some time and it's been very grey for some time, and that has been really difficult for employers because they don't know, and things change over time throughout the relationship. But now with these decisions, it's becoming more clear. The courts are saying if both parties have agreed to describe someone as either an employee and contractor, the parties should be able to rely on that. We don't need to look at anything else.
So what about things like working conditions, works compensation, like leave entitlements, superannuation? If you're paying someone X dollars an hour, but then you're not actually meeting the minimum actual bundle of package that you should be paying. So like, I don't know what the minimum wage is on an hourly rate, but then when you put superannuation, workers' compensation, all those extra costs in there, there'd be lots of people that would be class contractors being paid well under the...
Potentially, but that's for them to...
So buyer beware almost.
And like if you're not working as an employee, if you're acting as a contractor, potentially in your own business, you've got to price your services at the right level.
I guess the question is that I think, and look, I think it's a great finding to be honest, but I feel like there's a lot of naive people that would just sign. Like my daughter, I don't know, we're digressing a little bit here, but my daughter's 16, she works for a dance school, and they said, yeah, go get yourself an ABN and we'll pay you as a contractor. I'm like...
This is a massive thing in the dance industry.
I know, I just feel like she's 16 years old. To ask her to get an ABN, to ask her to invoice for hours. I'm like, what's your rate? I'm trying to do the maths. I'm like, I don't know. It's pretty sketchy. So it's really interesting.
Yeah.
Yeah.
Well, it's up to that person then to do their research and say, well, no, I'm not going to provide the services at that price. It needs to be higher.
Yeah. Because I can see Jacinta's a great example here. Contracts to Nathan. It's a clear contractor relationship. She wouldn't say, I'm working for you, so I'm an employee. Yeah. But my daughter's got one job. She's 16 and she's not in a position to make an informed decision as a business owner to charge and invoice someone. There's an imbalance of power, I think, in that relationship. So it's challenging finding, isn't it?
I had the same situation when I was younger, when I worked as like a tutor, It's the same thing.
It's really interesting finding that, such a blanket ruling, isn't it?
Yeah. Sorry, can I ask, don't you have to be over 18 to have an ABN, or can you be 16?
You can.
Tax file number and that's it.
Yeah. I know. I was surprised too, Jacinta. I'm like, no way. They can't do that.
Entering into a legal contract with someone under the age.
As a minor, basically.
Yeah. And I'm really worried about how they're covered legally.
They don't. They have to get their own public liability.
No, I mean, they can't sign a contract until they're 18 anyway.
Yeah, true.
Yeah. So that's like
that raises that.
It does.
Yeah.
It's dubious, isn't it?
Whether the contract would be valid, it would be another.
Then it'd be 18. But
So what happens with the superannuation contribution in relation to that situation?
Nothing.
Nothing.
She doesn't
That's
get
why
it.
they don't do it.
The
Yeah.
actual company and
Yeah.
provide 20%.
Trust me, I was on my bandwagon, and my wife's next. She's saying to me, "Stop it! She just wants the work. She loves. She dances there. She wants a job there. Don't just step out."
That's why you put up your hourly rate to cover all those.
Yeah,
Can
but she
I-
never said that. That was all given
Can
to
I-
her. So
can I just throw this back to Nathan here? Isn't there a section of accounting where if you're earning as a contractor income from only one source, then technically you're actually an employee and not under contractor?
that's what I
Well, I
thought.
think this is what Annika's.
Yeah,
one of the
that
features.
was-
That's
Yeah.
one of the features. And sometimes people would refer to like an 80-20 rule and
Yeah.
those
Yeah.
things. But in these cases, what the court's saying is that if
We're
you
saving
agree-
the world's issues in
But
one
if they're doing
afternoon.
their own time, and
Yeah.
like it said in your document, if that person is, as long as the deliverable is deliverable, but how that deliverable is done.
Also, I should say, there's an
up to the
exception to this.
individual.
It can't be a sham contract. So the High Court also said, provided that it's not a sham, that it's not a contracting agreement that is shared, like an employee. So it won't apply in that circumstance if they're just if the person isn't an employee, but they're just creating a sham arrangement.
Yes, where's that line drawn? It's hard, isn't
Yeah,
it?
exactly. That's
Yeah.
about
There is an
that's about
exception.
I'm in two
Pandora's
minds.
box.
One as a business owner, the other one as a father.
Absolutely.
Manos just says the Greeks do it right, they're just paying cash. That's the best way to go.
Well, the
Thank
Greeks
you.
are going to be stopped in about 10